Start? Okay. Good morning, everyone, and welcome to the Nathan Deal Judicial Center. We are live streaming this program, which is an early celebration of Constitution Day, because tomorrow is officially Constitution Day, as created by Congress. I'm Michelle Barkley, and I'm with the Administrative Office of the Courts. We are so blessed to have students from the Verda Arts and Sciences Academy with their teacher, Austin Colvin, with us today. This class was invited here to this program because their previous teacher, Dr. Christine Hartness, won a Center for Civic Engagement award, which is one of our partners for today's event. She won that award for her work with this class on a government and public administration curriculum piloted with this class. Our other partner for today's program is the Georgia Family Connection Partnership. Barrow County has experienced a terrible school shooting in less than 2 weeks ago. And these students that just came back to their school last week, as all the Barrow schools were closed for a while. We are very grateful that you decided to be with us today, and we'd like to have a moment of silence for the loss that these students and all of Georgia has just suffered. So please join me for a moment of silence. You honor us with your presence today. Thank you again for being here. I'm going to turn over this program to Professor Anthony Michael Kreis, who teaches constitutional law at Georgia State University School of Law. He is the author of multiple articles on law, rights, legislation, democracy, American political development, and he recently just published a book, Rot and Revival. I'm told from multiple people and from looking into social media that he's a lot of fun. His full bio is linked in your program, and Professor Kreis, thank you very much for doing this program with us.
Thank you very much for the invitation. It's great to be here, and good morning, everyone, and happy early Constitution Day. We've gathered here today, a day early, to highlight and celebrate our United States Constitution and the history of our government's founding. Constitution was created by Congress in 1998 to be celebrated every September 17th. But why? Well, because on September 17th, the delegates of the Constitutional Convention met for the last time to sign the document that they had created. The Constitution was proposed by men who had suffered a loss of liberty at the hands of King George III. They rejected the idea of being subjects and understood the dangers of being governed by royal power. But they also knew the power of democracy through years of local governance in their colonies and later their states. But in the years after the Revolution, they needed to create something new, a government not for 13 separate states, but for a nation. In creating a nation, the men who gathered in Philadelphia invested in Americans their belief that future generations would work to preserve the United States and make it better. And so the founders took the leap of faith that this document could be set up, or could set up a government that would work for and by the people. We are going to talk today about the Constitution, and I'm honored to moderate a discussion with two of our Supreme Court of Georgia justices, Justice Charlie Bethel and Justice Verda Colvin, and I'll introduce them more fully soon. We also plan to allow for a few questions from students before we end the program this morning. But before we get into a discussion about how to interpret the Constitution with our two justices, I want to talk a little bit about the Constitution itself. So the Constitution has a preamble, and it's perhaps the most famous part of the Constitution. A lot of people know it. They can recite it by heart. I can't do that, but a lot of people can. But in law school, we don't talk about it a lot, but it's really important, and it's invaluable to do so because it really shows a lot about our Constitution and how it was formed, the promise it had, the promises that were made but not kept, but later were made good on. It shows us how we can change for the better and how our Constitution is dynamic. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution of the United States. But there's two phrases in there that I think are really important. We, the people. and a more perfect union. And if we think about it, I think it's really helpful for us to show how we have a part in preserving and upholding the Constitution and improving our American democracy. The meaning of we has changed a lot, and for the better. When the founders wrote the document, we was really primarily thinking about white men who had the right to vote. Women were not allowed to vote except in New Jersey, but that soon was taken away in the early 1800s. We, the people, at one point did not think about Catholic immigrants from Ireland as being acceptable parts of the body politic, for fears of Catholics being more loyal to the Pope in Rome than to the Constitution. We, the people, certainly did not think about enslaved persons at the original part of the founding, but a civil war, a movement for abolition, radical Republicans in the 1800s changed who we, the people, were. In 1866, we get the Civil Rights Act of 1866, which is the forerunner to the 14th Amendment, and now we, the people, was a little bit more full, recognizing birthright citizenship, that if you're born here, you are a part of the United States of America. You are a part of the body politic. But the work didn't stop there either. As we know, there was challenges with immigration. People who immigrated from China were not considered we the people. People who were coming from Eastern Europe and Southern Europe were challenged and maybe not thought of as we the people. Women still did not have the right to vote until the 19th Amendment came into the Constitution. But a lot of work had to go in to changing hearts and minds about adopting the 19th Amendment. The phrase we the people shows how the Constitution hasn't always been true to the principles it stated on paper, but at the same time, the history shows that this nation and our Constitution has a great capacity for change. That if we constantly work for that more perfect union, we can get there. There's a lot of hope and promise in that message. And that's the genius of that second phrase, a more perfect union. The founders didn't say a perfect union or the perfect union, but they used language that recognizes that the work of democracy is never really over. The work of preserving and upholding our Constitution and the rule of law is never over. But it doesn't just come out of the ether, right? It just doesn't come out of anywhere or from nowhere, but rather it comes from a place of hard work and good citizenship. That if people do the work on the ground to make the union more perfect and to preserve the ideals of American democracy and our Constitution, we can move forward. Because again, the Constitution has a great capacity for change, but the Constitution is only as good as we are as a people. So let's move to our moderated discussion. We have Justice Charlie Bethel, who has served on the Supreme Court of Georgia since 2018. Before that, he served on the Georgia Court of Appeals, and before that, he was a state senator winning 4 terms. He was born in Athens, Georgia, and raised in Dalton, Georgia, and he's married with 3 children. We also have Justice Verda Colvin, who has served on the Supreme Court of Georgia since 2021. Before that, she also served on the Georgia Court of Appeals, and before that, she was a state Superior Court judge in Macon. She was born and raised in Atlanta. You have links for their full bios in your program. So let's turn to our conversation about the Constitution and its interpretation. So could you tell our audience about your path to becoming a judge or a justice and mention anything that influenced you, like mentors and things like that along the way?
Well, thank you, Professor, and I just want to echo the thanks that have been extended already to the folks that are present from Barrow Arts and Sciences, our friends at the Judicial Council and Georgia Center for Civic Education, as people who professionally care quite deeply about the rule of law, about the notion of having a written constitution that binds the conduct of people. We really appreciate the interest from those who are here and, of course, those that choose to watch online. In terms of a pathway to the bench, for me, I will start, and don't be discouraged by the start. It won't be as long as it sounds like it's going to be, and say that because you are students, I will start with my mother and my grandmothers, and I will continue with my father and my grandfathers, and then all of the wonderful teachers that I had along the way that both gave me the tools to sort of learn independently and gather information and think about things critically, and then also the encouragement to imagine a world in which I could actually help. And so my path to the bench was not a path to say, oh, I want to be a judge. It was really more a pathway of how can I be of service to the community and communities I live in as an adult. And that's what got me onto Dalton's City Council and ultimately into the state legislature. I had clerked for a judge a federal judge after law school. During law school, I had worked for Gary Andrews, who is now since passed away, but was a judge on the Georgia Court of Appeals. And so judging was a thing that interested me, but it wasn't until some trusted friends said, is this something that you would like to pursue when there's a vacancy or an opportunity? Would you like for us to nominate you as a practical matter? And I thought about it, and in our house, faith is a big part of our life, and prayed about it with my wife, and ultimately said, yes, this is a place where I think I could be of service, and I think I could offer something to the community in which I live. And so that's really the path to the bench. It has been a really gratifying service to me. I think I have enjoyed the work, enjoyed the people that I work with, and you're going to hear from Justice Colvin. I wish he could meet the entire court, and that includes staff, because there are wonderful people that work here that care very deeply about the work that we do, and that's always gratifying, no matter where you are. The people that you work with are what make it special or not. So.
Thank you, Justice Bethel. You all are so stoic, so serious for high school students, so I'm going to try to make it a little fun. So, like Justice Bethel, I never planned to be a judge. I mean, I remember sitting out in audiences like you all are sitting today thinking, what am I going to do? But I had always thought I wanted to do something for public service. So went to college, went to law school afterwards because I thought I want to be a lawyer. Never ventured being a judge. So I was a trial lawyer. I started with a private firm, was able to do all kinds of litigation, absolutely loved it. Left there, went to work as a general counsel at a university. Left there, went to the DA's office, or the solicitor's office first. That's who does misdemeanors. And I thought I could never work for the man. Like, that was like, who wants to do that? But then I got there and I saw how I could really help achieve justice and fairness because I was at the start of any prosecution. And so I fell in love with that work, went from there to the DA's office in Clayton County. And from Clayton County, I went to the U.S. Attorney's office, and that gig was in Macon, and so that's how I came to be raised in Atlanta but live in Macon. And so I was working at the U.S. Attorney's office trying all kinds of cases, and in one day walked my boss and said, I want to nominate you for the bench. And I'm like, eek, I can't imagine being a judge. I've been appearing in front of judges all this time, and you have your ideas about judges and what they do and how they do what they do, and I'm thinking, I don't think I want to be one of those. But then I thought about it, and I had been wanting to do more to really serve, and so I said, okay, I'll try this, but I'm just going to put my application in. I'm not going to really try to make anything happen. And so I did that and went to the governor and was appointed to Superior Court in Macon and absolutely loved it. I love interfacing with people, trying to make a difference. From there, I got calls about putting my name in for an appellate slot, and I resisted for a couple of years. But then finally one day, Judge Miller from the Georgia Court of Appeals, who will be retiring in December, she called me and she put me to the rug, like probably your parents do sometimes. And she was like, you talk about being a public servant and liking to help people. If you want to serve the public, you do what your state needs and not what you are comfortable doing. So I put in my application for the appellate position and got the Court of Appeals, and then thereafter I applied for the Supreme Court when an opening became available. So thank you all for being here today. Try to have some fun with this and try to really find something that makes it interesting to you so it won't be like another day of school, but something really exciting because you all are getting an opportunity that I never had when I was in high school. So thank you.
So let's talk about interpreting the Constitution. So a panel at the National Constitution Center recently said that they think there's 7 different approaches to the constitutional interpretation, looking at the text, history, tradition, precedent, the structure of the Constitution, prudence or reasonability, and arguments about morality or natural law. Do you think that covers it, in your opinion, or are there other things that influence how you think about the Constitution and constitutional interpretation?
I think when you look up the ideas of how people, jurists interpret the Constitution, all of those things come to mind, Professor. But I think when we think about that as jurists, it's like a compilation of all of that together. And so there's no one aspect of how you look at the Constitution that determines how you decide the issue. It's a combination of all of that, because different issues will require that you look at different aspects that control how we decide cases. And so I think it takes a little bit of all of that. Historical significance, morality, precedent, all of those things come into factor. And of course, we're always thinking about common law, because that's what controls our Constitution and how we look at the law.
So my answer to your question is, I think those 7 probably do cover the realm of things that people talk about when they go to interpret a Constitution. But that really depends on how you interpret those words themselves and how you use them. So people stretch words and lawyers stretch words, I think, more efficiently than any other class of human beings. And so you can take a word, and if I say it and you have a different meaning in mind, then what does it mean, right? Does it mean what I said, or does it mean what you heard? And so I think that you can look at those. I will say that I think all of those are relevant to the analysis that courts generally, not just our court, but do with respect to interpretation of constitutional text, but really also statutory text, and even all the way down to contract text. I tell people on a regular basis, I enjoy reading academic texts in the law, but I don't find them to be particularly helpful in explaining to the public at large what it is that we're trying to do. And so I describe this to people in my work, to folks who are students, just folks at large, I guess. I view my job as trying to enforce human agreements. And that's true whether it's Constitution, whether it's statute, whether it's a contract. Someone at some point in time before today agreed to a set of rules. That's what they do. Somebody did, and then a problem happened, and they come to court to say, how do the rules sort it out? What's the answer in this problem under those rules? And so my job is not to say, what do I think is a good rule? Because as Professor Kreis, you heard him list off, when the folks who framed up a Constitution for us told us what they were doing in the preamble. That's what the preamble really is. This is what we're about to do and why we're about to do it. What was the first phrase? Establish justice. And again, justice means many things to many people. But for me, justice means that the outcome is what the rules dictate. Because if justice is what does Charlie think justice is, then that's tyranny. Which is what we were trying to get away from, is an individual or a group of individuals who had the power to just make the rules as they went along and say, well, that's the rules. And so it's always an effort on my part, I think, to say what was agreed to. And there are many times when what was agreed to is not what I would have picked. But if I find myself saying, well, I think we should change that, then I am becoming a lawmaker. And really, that makes me, in this job, a lawbreaker. I had the job of lawmaker when I was in the legislature. That's where we're supposed to make the new rules. And those rules are subject to the rules of the Constitution, which is, of course, what we're talking about today. But I do think it covers it. But I think that what happens a lot of times, professors, that people want to explain an outcome, and then they pick what was the tool that was used to get there. And I think that for me, and Justice Colvin and I have talked about this, and our colleagues, proper judging is trying to find out what was the agreement and how does it apply to this set of facts. And you use all of those tools, I think, to get that question answered. But if you try to do it the other way around, you're really just trying to put window dressing on what you're doing.
Manufacture an answer.
That's right.
So before we get to more of the constitutional analysis and how you approach cases, let's talk about the Supreme Court of Georgia. You mentioned common law, you mentioned contract law. There are multiple constitutions. I'm a big fan of the Georgia Constitution. I think everybody else here would be too. So what kind of cases, what kind of constitutional cases does the Supreme Court of Georgia decide?
We decide, as the professor referenced, we decide questions of constitutionality under two constitutions. We are here today to celebrate the Constitution of the United States, obviously worthy of celebration, but Georgia has a constitution as well. And so we are presented with questions about the meaning of the Georgia Constitution on a frequent basis. And we are, under our system of government, the last word on the Georgia Constitution, such that whatever we say it means, that's what it means. And the only way to have that defeated is to have an argument that the U.S. Constitution forbids Georgia from having that constitutional rule. So they wouldn't change what our Constitution means. They would just say that violates the federal Constitution. But we decide lots of cases, the sorts that are going to be, I think, most familiar to you, things related to search and seizures. If you have a search that, whether there was a warrant, whether the warrant was supported by probable cause. You hear about those sorts of cases in criminal settings on a regular basis. One area that has gotten a decent amount of activity from our court in recent years deals with self-incrimination. You're all familiar with what are generally called the Miranda warnings. You know, have if you read them, they're Miranda rights and all those sorts of things. You have the right to remain silent, right? And we recognize that, and that is from a federal principle, but it's also a principle in Georgia's Constitution. And interestingly enough, the test is not the same. We actually have protections in the Georgia Constitution that exceed those. You can't have less than, because if you have less than, it just gets pulled up to. But we have provisions in the Georgia Constitution that exceed those that are present in the U.S. Constitution. And so our court has had a series of cases in recent years talking about that difference and how it applies usually to roadside traffic stops and those sorts of things. But in any event, those are examples of the sorts of constitutional issues that we have, and I don't want to take them from.
I think Justice Bethel has covered most of it, but I will say this because this came to mind as he was talking. Think of the U.S. Constitution, as great as it is, as being the floor. I mean, this is where you got it. These are the things you have to do. And then each state has its own constitution, and they can be the ceiling. So they can give you more rights than even the U.S. Constitution can give you. And I don't think people think about it a lot, but every right that's given to us in the U.S. Constitution is a right in which the U.S. Supreme Court, as well as the Georgia Supreme Court, and all the other state Supreme Courts look at, because they're the last word for each of the states, all of the state Supreme Courts. And the only one who can speak louder than each of the state Supreme Courts is the U.S. Supreme Court. So anything that you can think about that the Constitution gives you a right to, those are the things that our courts review on a regular basis. And in fact, we have exclusive jurisdiction over many of those things. So I just kind of wanted to give you that kind of ground base of understanding both the constitutions of the state as well as the federal Constitution.
So when you get a constitutional case, how do you begin your analysis?
Well, when I get a constitutional case in my office, first I want to read the parties' briefs, what they've said about the issue, and then I go to the text. So for instance, I'm kind of a dweeb. I have my own copy of the U.S. Constitution. So a lot of times I will actually read the text that is germane for this Constitution, the federal Constitution, or the state Constitution, say, what does it say? And then after I see what it says, then I look at the cases that have talked about this particular provision, and I read those. And then sometimes we go even further than that to look at what common law was before this case came out. And then I try to make some analysis and I don't think of myself, I don't put myself in one of those categories. Some people will say, well, I'm a strict interpretation of things. I don't really go in a category. My thought is, what does the law say? What does this say? Does it fit? Does it apply? And how should I analyze this? And so that's what I do. So I can't really put myself in a box, but that's how I start the process of determining how I will analyze a particular issue or situation.
And I would say that my process is fairly similar to what Justice Colvin has outlined. I typically start, whether it's a constitutional case or not, by just trying to familiarize myself with the briefing from the two parties. One of the hallmarks of our legal system is what we call the adversarial system. So invariably, there are at least two different points of view being argued before the court. Sometimes there's more than 2 points of view, but I try to look and just, okay, what are they arguing about? What do the parties think this case is about? How have they argued it, both before our court and more often than not before a lower court? And sometimes you see that their argument has changed, and then you say, well, why has it changed? Why did they move where they were pointing to, or in the cases that they were citing? And then, like Justice Colvin said, we look at the text. All right, so I now know what they're arguing about. Let me turn to the rule, and then we look at cases. And I know inevitably we're going to talk about the concept of precedents, but we look at cases and say, how has the Supreme Court interpreted this language, if they've interpreted this language, but also other courts that may be not binding on us, but they're persuasive, because when smart people have taken the time to do the work, you ought to at least read what they've written and say, well, do I agree with that? Do I think they got that right? And so we listen to persuasive court interpretations, and then we come back and say, okay, now we've educated ourselves, and we come back to the problem that we're being asked to solve and say, can we see the application of this rule to these facts?
So let's talk about history a little bit. How does history play a role in your constitutional or your approach to constitutional interpretation? And can you give an example of how it's played a role?
So I think history plays a role in, for me, a couple of different ways, and you think of the way the court does its work. You've heard mentioned a couple of times the common law, and it seems like that would be a pretty easy thing to describe, but there are professors and academics who have spent their whole career trying to describe it, and they don't describe it the same way, so it must not be that easy. The common law was a notion that evolved out of the English system of law prior to the American Revolution. So it's the system that was in place generally in the colonies that became states. And the common law was this argument that there was some law, or this concept, not argument, this concept that there was some law out there that governed the affairs of humanity and was common. And our job as judges and lawyers and barristers and all these sorts of things was to seek out and sort of uncover. We were like archaeological, on a dig, right? We were going to uncover the common law. And so as cases would come, courts would decide, and then if other courts were persuaded, yes, this must be the common law, then they would sort of piggyback on. And so there's this rich history of the common law that predates the American Revolution and really created the framework that most of the scholars, most of the framers of the Constitution would have been skilled in, steeped in, and knowledgeable about. So when we say we look back to the common law, what we're really, to me, what I'm saying is it's helping me understand, as I said earlier, the people who were making the rules, when they made the rules, what was the language that they used? There are words that we use in common English that they had never heard, or if they had heard, they didn't think they meant the things that we mean. So we try to look at what was the world they were living in, what was their linguistic base, how are they going about making this rule? The other thing that's important, and I'm just a quick tangent, and I'll let Justice Colvin talk about history and the Constitution, is that in Georgia, on a specific date, our General Assembly adopted in our code the English common law as it existed on a specific date as the baseline rules for Georgia. And then, believe it or not, even though they make new laws every year, there are still spaces where the argument is made, The General Assembly has not legislated in this space, and so it's the common law. But it's not the common law as it's continued to move and be opened up and explored. It's frozen in time as it existed at this point in time. So then what do we have to do? We have to go back and find common law, English common law cases. Sometimes they're opinions from American courts that were from around the time of the American Revolution, and say, what did they say about this issue or this right at common law? And then we have to try to figure out how does that translate now, over 200 years later into our world. But history?
History, I think, impacts everything we do. I mean, our laws are based upon the historical document that was founded by the Founding Fathers, the Constitution. So history goes into all of everything that we do. And in fact, it's funny because as the professor asked that question, as Justice Bethel was answering, I was thinking, even our interpretation of history differs. I may see something from a historical standpoint, even looking at precedent, that maybe my colleagues might not see. So when you talked about an example, the one example that comes to mind, I know I was a dissenter from the court on the idea of self-incrimination as it's defined within the Georgia Constitution, because the way I saw the historical significance of what had preceded that was different than my colleagues. And so even when we're looking at history, which is important to every decision we make, our view of that history is sometimes different in how we interpret that and how we juxtapose that on the new questions that are answered even today. So it's everything, but it's not all things. And I think that's important for you all to remember. The history helps us do our work, but it is not everything regarding what we do, because there are other things that come into play as well.
So you both have mentioned old cases, old court decisions. So in light of that, can you explain what precedent is and how it works?
Precedent means what preceded in time. So basically, the way we've been describing it to you all is cases that preceded the case that we're looking at. And so that's important. How do we keep structure? How do you all keep structure even at school, in your classes, in your own life? By kind of doing the same thing you've done, so that so one day is not one way, one day is not another day. Like, you might change your hair routinely, but you don't change it every 10 minutes. Well, hopefully you don't, but sometimes you might. But precedent is that thing that has existed for some time, and the reason why it's so important is so that we can keep the structure that the Founding Fathers tried to implement when they came up with the Constitution, because we can't change the way we do government every day, or according to our whims, or what may be popular today or tomorrow. We have to have structure. So precedent helps us keep that structure, because we look at what was decided before and we use that to decide what we're doing now. But there's a caveat. There's always a tinge of difference in the next time you look at something. Or maybe something has changed. Maybe an amendment came out that makes the way we look at that differently. And so, but it's not supposed to be based upon the whims or the desires of the public at the time. It's supposed to be based upon what the law is and a logical extension or a logical analysis based upon that law. And that's precedent. It gives you a jumping off start to do what you need to do in the new issue that comes before you.
I echo everything that Justice Colvin said, and will just add, for your purposes, as you hear and think about precedent and you engage in the conversation around the system of laws, there's a phrase that you'll hear a lot called stare decisis, and I have no idea if I pronounced that correctly because I don't speak Latin, and I hope you don't either, and if you do, you can tell me afterwards that I got it totally wrong. Lawyers import words from other languages on a regular basis. I'm pretty convinced it's just for the purpose of making things more complicated. But what stare decisis means is the thing is decided. So a thing that has been decided in our system of laws, or sort of going back to that common law tradition, when a thing that has been decided, and particularly if it's been decided multiple times, particularly if the court has followed that precedent and said, yes, this is good precedent, we think that's the correct interpretation, then it gets heavier and heavier and heavier over time because it's been decided. And One of the things that a system that establishes justice and the other sorts of elements that we talked about in the preamble of the Constitution is to provide predictability. One of the goals is to provide a predictability so that citizens can know, if I do this and it comports with these interpretations, I'm going to be allowed to do it. I'm not going to be thrown in jail. I'm not going to have it taken away by the government. I'm going to be able to make money off of it, whatever it is that I'm trying to order my affairs. And so that's the weight of stare decisis. It doesn't exist to protect things that are correctly decided. It only really matters if a court thinks that a prior court made a mistake. Because if you think they were right, you just would say, well, I think they were right, and I would reach the same outcome. It's only when you say, I think they were wrong. And then you have to do the calculus, and there's a set of rules, and people talk about different weight for different prongs of it. But what you're really saying is it worth disrupting? Is the error that I perceive in the decision of the previous court worth disrupting sort of the sense of stability and predictability that exists within sort of the larger swath of society? Is that fair?
And I took Latin in high school and college, so
Well.
you got it as I would. So, but I think it's important, right? Because obviously you need to get majorities on a court in order to have decisions made. But if that inevitably comes with some disagreements, surely. So, how do you handle disagreements among the other justices when you are trying to decide cases?
So I will say that my 6 years, I guess now, wow, that's 6 years on this court, and the 2 that I was on Georgia's Court of Appeals, have been delightful with respect to that question, with respect to how people handle disagreement. One of the things that I will say is important, I perceive, is the culture of the court. We have a court that cares very deeply about one another as individuals, as human beings, our families, the experiences that we're having in life. And so when we reach professional disagreement, and I'll just use Justice Colvin because she's next to me. When we reach professional disagreement, we think the answer is opposite or not the same, maybe not opposite, but we don't agree about the outcome. What I know, because I know her, is that she believes that, and she believes she is discharging her oath to the people of Georgia in that position, and that she listens to me. When I say, well, no, I think it's this, I know that she, even if she thinks I am just foolishly wrong and off base, as is probably often the case, but she listens to me because she cares about me, but she also cares about her oath of office. I know that about her at a personal level. And so if we disagree, and I hope she feels the same, is reciprocated on my side. So if we end up disagreeing, then our system has worked. Because we have a panel court. Normally there's 9, right? There's not. We have a panel court with the idea being that by putting people together, we decrease the likelihood of making a mistake. And so we build to a majority. People have, I think, this impression that when you're in the minority, like that there's a divided court, that is always somehow upsetting. And that may be to other people. It is not to me. It's not really, it doesn't bother me at all because I trust all 9 people that are, all the other 8. And so if there are 5 or more that disagree with me, they're serving me. I'm on this court, but I'm a citizen of Georgia, and if I am wrong, I want them to win. I just can't give up my own point of view because of that. And so I will listen, and if I'm not persuaded, I'll say, well, I see it differently, but you've won. And if people dissent and I'm in the majority, I don't take that as a personal thing because they're good people who are working hard to get their version of the right answer, and that's how we work. So that's been my experience, and I'll let Justice Colvin.
What I think about when you ask that question, we really work to compromise. It is really a court that works to compromise, to come up, if we can, if it's all possible, a unanimous majority opinion, because we know that helps practitioners, it helps the public to know what the state of the law is in Georgia, and they don't have to worry about it being turned upside down within a year or two, or another factual scenario comes about. But when that effort toward compromise and working to get the best result or best opinion possible doesn't work, then everyone respects the other side of the coin. And this is the beauty of it. Even as you write your dissent, the other justices who might be on the other side, they will give you suggestions to make it better, even though they disagree with the rationale and maybe the analysis. But the bottom line for our court is we want the best product to come out of our court once we finish, and we want thoughtful analysis, so that if later on, 10 or 20 years, when one of you all is sitting up here and you say, wait a minute, they were wrong, but this dissent is right, and we've recently done that on a case, a dissent from maybe, 20 years ago or something. We said that lone dissenter, the one judge who dissented by themselves, was right. You know, doing that correctly and being very thoughtful about it helps the future. And so that's kind of how I look at it. If I have to dissent, or if I'm joining a dissent, I've joined a dissent with that Justice Bethel has authored. I'm thinking we're helping the law, because later on down the line, someone may say, yeah, that was it. And so, and it helps practitioners to think through concept and ideas that they may not get if it's just a majority opinion, because there's no real exchange of thought when you just have one viewpoint, right? So I see it as a win-win no matter what.
So the Constitution doesn't, at least formally, change very often. Do you think it should be easier to amend?
He punts to me first. I thought about this question a lot when we received it. I don't think it should be. I mean, we have the longest standing document ruling a society of any other place in the world. It's because it encapsulates all the ideals that we hold true as Americans. And so I think we have to be very careful when we're trying to change and restructure things. Yes, I think, of course, they lived at a different time, and so we have to, on some level, we're evolving, but I think we need to be very careful and really thoughtful as we add amendments, or as we change, if we change the Constitution itself. That document, the beauty of it is so general that it encapsulates so much, but it's so specific that it really defines and clarifies those things that will hold a nation together. And I think that matters, and that's why I have my own copy, because I read it sometimes and I'm like, how are these guys so smart? And I can tell you what I think, the reason why this document has been so profound, but it just matters because this document did things they didn't even intend to do. They didn't intend to give everybody the right to vote. They didn't intend to ensure that everyone who was on this land was considered a full person. But the way they wrote the Constitution was such that everybody gets to say, hey, that's not keeping true to the words of the Constitution. And something you said, Professor, a more perfect union. I had never concentrated on more, as many times as I've read that. And I think what that meant is the founders knew on some level. We'd have to think about some things and maybe recraft or put a little nuance to some things, because we're trying to build that perfect union. And so because of that, we have to be open to looking at change, but we have to remember the reason why this document has been so profound and lasted so long is because it is, a good foundation.
So I'm going to give you the quintessential lawyer's response, which is I'm going to give you, in my own brain, there are two answers to this question, and so sort of it depends, right? Interestingly enough, for those that are in our room, I'm not going to call on anybody, but you may not know that the Georgia Constitution, the whole thing, has been rewritten many times. In fact, the one that governs us today is the 1983 Constitution, and it has been amended several times. So it's not true that constitutions aren't amended, can't be amended. They are. Ours has not. The federal Constitution has not. It is difficult to do, or has proven difficult to do. I'm not sure how the framers would have perceived what our experience has been in terms of amending, if it was consistent with what they expected. I actually also think that a good number of the framers did actually want the things that Justice Colvin mentioned that they didn't intend to do. I think a good number of them did, and they tried to create the architecture in the Constitution that was big enough and bold enough to allow the people to figure out and fix the things that they were unable to fix. Now, some of those people didn't think they needed fixing, right? So, I mean, and that was the fight. That was one of the fights that they were engaged in at the time that they were framing up the federal Constitution. But I think the beauty of it is that we get to decide. You and I get to decide, you know, do we want a new one? Do we want to amend the old one? That's the structure. I do think that one observation I will make is that I do think that the framers, many of them, not all of them, many of them probably would be surprised that we were still operating under that Constitution. Many of them, I think, would probably be surprised because they wouldn't have expected what they built to last this long. And so we have found ways, sort of like when I used architecture earlier, I do actually like to think of sort of how we've built a country structure and a governmental structure that way. We've added on to the house. We've sort of, and we've kicked out walls and said, well, we can make this work for the interest of holding on to something that I do think is powerful and beautiful and brilliant and also flawed, just like every human endeavor. And so we've sort of made this Constitution continue to work, and I think that's neither good nor bad. It's just what's happened. And so we have the ability to change it. We have the ability to amend it. But I think one of the consequences of what we've chosen to do is that we want it to amend, but we don't want to expend the energy to amend it as citizens.
We have a few questions from our students to round out our program here today, so why don't you all come and ask your questions.
Question for you is, are there any cases that bring you heavy emotions, and if so, how do you deal with those emotions?
Yes, there are, and there are loads of cases that bring me heavy emotions. Much to, well, I don't know, they're actually pretty good with it now, I think maybe when they were younger, but much to my children's embarrassment, at some point in my life, I am a crier. I am an emotional person. And so we read the record in every murder conviction in the state of Georgia. It comes to this court and we read what happened. That is just, it's emotionally expensive. We hear regularly cases involving children who are hurt and mistreated by people who are supposed to protect and provide for them. That is emotionally taxing, is emotionally demanding. For me, I try to stay, first and foremost, focused on what it is that I'm being asked to do. So if you think about, other professionals, when a doctor walks in and sees a patient, it's in terrible condition. If the doctor gets caught up in the emotion of what's happening with the patient, they can't do their function. And I have a function, and that terrible situation is entitled to me doing my job. And then on the backside of that, the same sorts of things that I think everybody would advocate for anybody who is dealing with emotional or traumatic subjects, which is, for me, that's work through it with my own faith system, work through it with counselors, work through it with whatever it is that allows you to process what you're experiencing at that emotional level in your work environment. And that's not just true of judges and courts. I think that's true of all sort of functioning adults. But yeah, definitely it is. And we work through that as efficiently as we can.
And I'd say ditto to what Justice Bethel has said, but because I've been a trial attorney, state and federal, it is not nearly as taxing as it was when I was trying those various cases. But when I read a record, I'm there, because I've been there and I've seen those kinds of cases. So it is hard, but not nearly as taxing as it was when I was in the mix of it and dealing with the parent who lost a child or whose child was killed by someone who just did atrocious things. So it is difficult on this level, but much easier than it was when I was in the trial level.
Thank you.
Thank
Thank
you.
you, Lucas. Sadie, you're up next. All right.
I just want to say thank you y'all again for having us. This is a great experience. And my question for you is, what is the most difficult ruling you've ever had to make?
For me, it was as a trial judge, when I had to sentence a child who was 16 at the time. By the time he got to me, he was like 17 and a half to life in prison. That was, I mean, I still think about him all the time, and I'm spiritual, and I pray that even with that sentence, he somehow finds himself and redeems himself so that he can have a life at some point that's outside of four walls. On this level, hadn't had one that really moved me like that. I think having been a trial judge, you're more in the thick of things, and so things are more directly in your face. But here, I haven't had anything that really disturbed me a lot. I guess one case that I sided with Justice Bethel, it probably was the one that bothered me the most. And it was a case involving a child.
So for me, they come in two categories, and I'll give you, sort of what those look like. When you say difficult, the question is it difficult to get the law? That's the first category. And so we've had a few cases, and the challenge we have is that we typically allow our opinions to speak for themselves. So I won't give you an example of this piece because we like whatever we said in the case, that's our articulation of the law. But there are cases where it's really hard to figure out what the law is because the legislature has written this into our code, and they may have actually written another provision somewhere else, and they weren't thinking about it at the same time. I mean, they wrote, and the fiction of legal analysis is that we assume that the General Assembly wrote everything to be read harmoniously. And the reason you assume that is there's no other rational assumption that you can make. You can't say, well, we're going to interpret this, and we know they had no idea what they were doing. Right? But that's true. I was there. I'm not throwing stones at them. There's no one in that building, as they're working through their 40-day legislative session, has full knowledge of all the rest of the code. And so we do that. But there's times when you say they didn't account for these facts, and so that's very difficult and very hard because it is what we say, as I said earlier. It's very rare that it goes to the Supreme Court on some federal constitutional issue. So when we've said it, nobody comes back and says, are you sure, right? I mean, we can get a motion for reconsideration, but as a practical matter, when we've said this is now what the law means, that's what it means. And so there's that part, the getting it right part. And then there are cases where the outcome is sort of emotionally taxing or demanding on you. And I'll give you an example of one of those. When I was fairly new on the Court of Appeals, the panel that I sat on handled a case where I actually do believe that the State Board of Pardons and Paroles, which is what they argued before our court, made a mistake. They did something they did not actually intend to do, but they issued a signed, sealed, finished pardon to someone, the provisions of who had been convicted of sexual-related crimes, child sexual-related crimes, and they excused that person from being a mandatory reporter. They're empowered to do that. And their argument sort of before the court was, well, that's not what we meant to do. But as I said earlier, I don't get to say, well, then I'll just change the law and I can fix it for you. You have this great power. Georgia gives, interestingly enough, for those of you who have curiosity, governors don't have the pardon power in Georgia. The State Board of Pardons and Paroles has an incredibly awesome power. And it can be exercised for good. But you better be careful when you issue a pardon, because when you issue it, it's done. And so that, that's one where similar, so on the inverse side, I hope that person has not abused that being relieved from that in such a way that it's detrimental to another person. I mean, it's just, but you worry about those things.
Thank you, guys.
Thank you.
Thank you.
Helena? Back and clean up.
Last one from us is, how do you balance your personal biases with the need for impartiality in your rulings?
You know, it's funny you ask that, because that's something I had to think about when I went from, well, you have to think about that anytime you enter the judiciary, but I think on the appellate court, you really think through that. And what I remind myself all the time, every day, particularly if my inclination is for one way or another, is that this is not about me, that I have to have a divided being. You know, I have my own personal beliefs, thoughts, motivations, interests, but when I'm making decisions for this court, I am duty-bound to follow the law, to do an analysis that is sound and that makes sense in light of precedent and history. And I've even said to one of my colleagues before, I don't like this decision I had to write, but this is the right decision because I'm following the law. And I'm not going to do something where I can't, in good honesty, following my oath, follow the law that's there. Because my thought is, that's for the people to change if they don't like. It's not about me changing it or interpreting it the way I think it should be. It's about the people of the state of Georgia changing the law through legislative action by their representatives, by amendments or things that come on the ballot for them to decide, issues that come up, but that's not about me. So it's really having a conscious effort every single day to make sure you're following your oath and not doing your own will. And I think that's so important. And so I stay true to that.
I would associate myself with that articulation from Justice Colvin and say that for me, that's an integral part of the job. I mean, it's not like something you have to think about some of the time. It is the foundation of being a good judge includes, I mean, you have to have discernment and those sorts of things, but the ability to set aside your personal biases, preferences is foundational to doing judging properly. And so for me, the ones that I worry most about are my own biases that I'm less aware of, right? So the ones that I know, this is not meant to be a flippant answer to your question, Helena, but if it involves Georgia football, I know that I'm biased, right? So I walk in and I am clearly biased, right? So I'm aware of that, and then I have to take steps to do it. But are there areas based on my experience, based on sort of my own sort of lived experience, my own beliefs about the world, where I have biases that are sort of opaque to me? Those are the ones that I worry about. And in terms of making sure that I'm trying to educate myself on a regular basis, I try to read sort of a broad base of material a lot. I try to read things that challenge me in the way I think, not necessarily even for that issue, but to practice that skill of identifying it. And then we have wonderful staff. I mentioned them earlier, and we have wonderful colleagues. Part of the value of a panel court is that there are 9 justices. Each of them have multiple attorneys in their chambers, and we are all looking. And in my chambers, my rule with my staff is, if you hear me talking about a case that's different, that sounds different than my normal process, then you are empowered and in fact directed to come to me and say, Judge, it seems like there might be something else going on here. And we hopefully have an environment of trust that supports that within my chambers, but also colleague to colleague, and say, hey, on this area of law, you're always in this line and you've been consistent here. Is there something that I'm not seeing? Because that's also possible about the case, but also is there something going on here that may be sort of prompting you to lean a way that you're blind to? Does that make sense?
Yes, sir. Thank you.
Thank you.
Thank you.
Thank you for your questions. And to wrap up today's program, we'll have some closing remarks from the justices.
Well, What else is there to say? I hope that, I know sometimes studying the Constitution and history, I'm going to be honest, when I was in high school, that was one of my least favorite classes, history. I wasn't a history buff. And it's funny because as I've gotten older, I really like history. And my son is the total opposite. He can tell you every historical thing that ever happened. And so I love listening to him. Now, I like history, but I hope you all will take from this today the opportunity to really think about history, think about what it means to you, and think about the value of the Constitution. And maybe just get a copy of it and every now and then just, look at it and read it, because you all are coming into an era that is different than the era that Justice Bethel and I grew up in, and you're going to have to wrestle with these issues and the things of the day that are coming up that are germane to everything within our society. And so having an understanding of the historical significance of the Constitution and of our previous cases will mean everything. Because if no one's told you lately, you will be the leaders. You are truly the leaders of tomorrow. I will be sitting back in a rocking chair and you will be just leading the world. And so it's important that you start thinking about those things now and what those things mean to you and how they, the value that they have as you move forward. So thank you all for being here. Thank you for saying yes to the class, and thank you for being engaged.
Well, I will echo that too. I share those views and extend that same challenge to each of you going forward. And I'll just close as we talk about Constitution Day and the Constitution itself with an encouragement for you to think about something. We often talk about what's in the Constitution, but I think it's also important to think about what it represents and what that representation means for us. We live, you and I, in my estimation, in a culture that's very outcome determinative. And what I mean by that is, if I got the outcome from some process, from some person, from some event, from some court that I liked, then that's a good process or a good court or a good person. And if I got an outcome that I did not like, they are bad, evil, hateful, bigoted, whatever you want to learn. They are terrible because I didn't get what I wanted. And when we adopted a constitutional form of government, the people that did that were flawed. They were just as, or even more flawed, maybe, I don't know, as each of us, as we are. But one thing they believed was that you had the ability to govern yourself. Not somebody else. It's not somebody else's job. They claimed for the people, we the people, this idea that we could govern ourselves without some divine right, without some hierarchy, without lords and dukes and earls and all those. We could do it. The only way they can be proven correct, there was a lot of things I think they were wrong about. I think they were right about that. I think that we can do it. But that means that we have to be committed to knowing the rules, to, if we need to change the rules, finding out how we go about changing the rules and changing them and being a part of that process, as opposed to sort of passively looking at it and saying, I don't like these rules. These rules don't work for me. That's the mindset of the old world. We live in the new world. And the new world empowers us as people to know our own rules. We don't have to guess. We don't have to wait because they're already written down. Somebody gave them to us. And then, if we don't like them, we go out and find our friends and change them. That, to me, is sort of the enduring legacy, the positive enduring legacy of our constitutional experiment. And I'm glad we're still working on it.
Well, I think that was a great way to end the program, and thank you for coming. Thanks to everybody who was watching, and thank you for a great conversation.
Thank you.
Thank you. We appreciate it.
Thank you.
Thank you all.